hearing and decision today. The court's decision is it needs to deny the motion, and here's the reasoning why. Pages 8 through 10, case 886-110, State of Nevada versus Meta Platform. And for today's purposes, we're calling it messenger case only, correct?
Yes, Your Honor.
Okay, so feel free to make your appearances on behalf of the state of Nevada, please.
Thank you, Your Honor. Phil Carlson, Pro Hoc Vice for the state of Nevada. With us today, we've got Mike Gayan with the Claggett and Sykes Law Firm. We have Raquel Fulgham with the Attorney General's Office. We have Richard High with the Claggett and Sykes Firm, Joseph Larita with the Kemp Jones Firm, Sam Feely with the Attorney General's Office, and we have Lily Kaufman with us, who is an intern in the Attorney General's Office with the Steiger Fellowship Program. She just finished her 1L year at UNLV Law School.
Sounds great. Anybody remotely that you need to introduce?
See, I don't see anybody online for us at this point in time.
Okay, well, after we get through defendants, if you need to add some, feel free to do so. Okay, on the D side, please.
Good afternoon, Your Honor. Tammy, Peterson, bar number 5218. For the defendant with me this afternoon, Mr. Timothy Hester, who's admitted Pro Hoc Vice, Mr. David Sneed, who's also admitted Pro Hoc Vice, Dan Waite, and Dan Polsenberg, both been the Womble bond.
Something. Good afternoon, Your Honor.
Thank you. You have, is that,
I do have another gentleman here who's not making an appearance. I actually told the clerk I wasn't going to say his name, but his name's Patrick Nutter, Nutter. He's not making an appearance, he's not speaking, he's just observing on our side.
okay, no worries. Any of the remote people yours? They need to belong to someone, right? Do any of the remote people belong to you?
Yes, Abigail Porter and Zora Franjovic are associates with our firm, but they are observing only.
Okay, no worries. Well, I just want to make sure, sometimes people like to have their names on records, and so, give everyone a chance to, they can say, guess what, I did a court appearance on X date, or whatever. So, yeah, it's all good. Okay, any new names that you see came up on the P side that you need to add in?
No, Your Honor, none from the state. Thank you.
Okay, appreciate it. Okay, so welcome to round X, right, of the concept of a preliminary injunction hearing. So for today, technically what we have is motion for leave to supplement the record on OST. So it's plaintiff state of Nevada's motion to supplement the record on order shortening time, document 223 redacted, appendices. I'm not going to go through all those. And then we have Meta's opposition and Meta's supplemental opposition, plaintiff Nevada, state of Nevada's reply. First opposition was 231, the supplemental was 290, and the state of Nevada's reply was 298. Last document filed on 5/21, according to what we show. So first off, I want to make sure, because since this is supplements of supplements, et cetera, is those the correct pleadings, or does anyone think that there's some other pleading the court should be considering for today that was filed?
Your Honor, Phil Carlson for the state. I think that's it.
Your Honor, David Sneed for Meta, that is it.
Okay, perfect. And as we said earlier, I said earlier, understanding this is messenger case only, because you all put the parentheticals for messenger case only. So, okay, so you have your special setting. Did you all come to any kind of agreement of how long you each needed to speak, or kind of what order you wanted to do, or anything like that, or are you just going to leave it to the court?
Your Honor, we didn't come to any specific agreement on that, and we'd be fine leaving it to the court.
How much time do you need? Let's see if each side's got about the same amount of time, and that's the fair way to do it, or if there's something different I need to do.
Your Honor, I think I could get through everything I've got to say in about 30 minutes, including rebuttal time. 25 minutes or so to begin with, and then 5 for rebuttal.
Does that meet the needs of defendants, or do you need something different?
30 minutes meets the needs of defendants, and I will
Okay.
endeavor to be shorter.
And as you know, that doesn't include questions from the court, if by chance I happen to have any. Okay, so that means it's your motion. Feel free to proceed.
Thank you, Your Honor. Your Honor, Phil Carlson for the state. Want to start out by saying that in this particular matter, the court is sitting in equity. And so the court has pretty broad latitude in equity to determine what evidence the court wants to consider and what evidence the court wants to hear. The rules of evidentiary procedure are relaxed in equity, and so we wanted to just kind of point that out to begin with. And what we're here today to discuss should be an issue or should be a non-issue. The question of whether there would be additional evidence in the preliminary injunction matter was never in question. But when the state presents the evidence that Meta finds damaging, Meta portrays a false narrative. And I've got 4 points that I want to mention through this to show what the truth of the matter is. The first point, the record was never closed on the preliminary injunction motion. The second point, the state's ability to supplement is clear in the rules and in the case law. Third point is that the state is not responsible for any delay in this matter coming before the court. And finally, that the evidence the state seeks to introduce is appropriate for supplementation after the hearing. And that includes evidence that wasn't in the custody or control of the state, evidence that didn't exist at the time of the hearing, and evidence that we are submitting as rebuttal evidence to some of the witnesses that Meta put forth at the hearing.
Before you kind of go into your specifics, let me ask you a question, because it's a framework question. I'm going to really ask both sides, okay? You can appreciate, while I'm in no way ruling on a motion that is set to be heard by me on June 17th, 2025, titled Meta Platforms Motion for Leave to File Post-Hearing Brief in Opposition to State of Nevada's Motion for Preliminary Injunction. I'm not ruling on that. I'm really utilizing that with a framework question. I'm going to ask both sides. So from your standpoint, the framework of what the court would be considering, right? We're going back to an underlying motion for preliminary injunction with a segue to discovery on personal jurisdiction, some other segues agreed upon briefings and all sorts of things. So what, from your state standpoint, is the structure of what the court should be considering when it actually makes its ruling on a preliminary injunction?
On the preliminary injunction itself, Your Honor?
Or you're supplementing the record, right?
That's
But you're
correct,
Supplementing
yes.
the record for purposes of preliminary injunction, are you not?
That's correct.
Because that's the operative ruling that you all want at some point when you all decide that you're done with all of your
Yes.
different little roads.
Yes.
Away, right? But
Yes.
that's what I'm saying. So to get to decision by court's going to need to take into account something, right? What's your structure of what the court should be taking into account, as well as, I mean, I don't know if you're going to tell me, guess what? You want a post-hearing supplemental brief. And I'm not saying I can address it today because they just filed their motion. It's not set till June 17th.
Of course.
But I have to have an understanding of what each party's framework is, because as you mentioned, the court sits in equity. If one side's saying, no, they can't have it, but we want it, and the other side saying, no, they can't have it, but we want it, you can appreciate, I have to evaluate that from an equity standpoint versus both sides saying, sure, we'll both add X, Y, or Z.
Of course, sure. Well, we think the framework that the court should be working in is looking at the evidence that was presented both at the original hearings in March of 2024, that was March 20 and 21, along with the motion briefing that was submitted there. And then this material that we're presenting today, we believe should be included in that consideration because we believe it's valid material and proper to be included in the court's evaluation. So we're talking about the structure of what the court should be considering. We think those are the things that should be included.
So should they get a chance to respond to your, if the court, and this is, don't read any tea leaves, there's no tea leaves here, but the reason I'm phrasing is a structure question. Are you saying that they would have a response to your supplemental and the court should consider that? And when does this stop? And then is there post briefs after that? That's why I'm asking my structure question.
Again, without reading the tea leaves, I think we're going to be opposing Meta's motion to convention the second hearing June 17th. So I think the answer to that portion of your question is no, we don't believe there should be that. To the other question, I don't think that we've actually landed on a specific position here, Judge. But I think if you're looking at the equitable standard that you have, that we present here, I think the court could well determine that Meta would have an opportunity to present some additional evidence. That being said, I do believe the state would get the last word as we brought the motion. The motion for preliminary injunction.
That's why I need to declare, as you can appreciate that. It's been the pleasure of multiple motions, so I just need to clarity. So I thought you were talking PI, but I wanted to make sure. Okay, go ahead, please.
Thank you. All right. So the first point we want to discuss is that the record in this matter is not closed. The court, I'm sure, remembers ordering discovery after the hearings on March 20th and 21st. And so clearly the record isn't closed. Additionally, the court hasn't issued a decision in this matter.
How can I? You all keep asking for additional briefing and then do your own steps to extend. I would love to have done a ruling back in March of 2024.
Certainly.
Sorry, go ahead. That was not a negative comment to anyone. It's just when you say the court hasn't done, someone could take that isolated statement like you're waiting for something from the court. Does
Mhm.
anyone think you're waiting for a court's decision right now?
No, we don't, Your Honor.
Defense, do you?
No, you're on.
Okay, just making sure, because it's not my under advisement list, which is right now is at 0.
Absolutely true.
Okay, go ahead, please.
Absolutely true. But because there hasn't been an order issued in this case,
I got
the
it.
record is still open in the state's view. And so we don't believe that when Meta contends that the record is closed, that that's accurate. We believe the record is open and has remained open. The second thing that I want to discuss is the state's ability to supplement under the rules and in the law. EDCR 2.20A contemplates the filing of exhibits with briefs. It says briefs in the language, and that is something that Meta has pointed out in their responses. However, if you look further on in EDCR 2.20, specifically subsection I, that says that briefs can't be bare. They have to have support there. And then looking on to other portions of that section, of that rule, it discusses that briefs have to be filed with exhibits, or discusses how briefs are filed with exhibits. EDCR 2.27 directs how to file exhibits that accompany briefs. The authors of the rules, in this particular case, the EDCR, could have stated that briefs under 2.20I, supplemental briefs, were different from all other briefs and would not have exhibits attached, but they didn't. They didn't specify that supplemental briefs would be different. And so the point that Meta is trying to make fails because of that. The second portion of this kind of statutory and case law framework argument that I'd like to discuss is that the evidence that we're trying to submit is appropriate for this particular motion, for the preliminary injunction motion. Rule 65A2 clearly contemplates that evidence that we're presenting doesn't have to be admissible at trial. One of the main contentions that Meta makes is that the evidence that we're submitting isn't admissible at trial because of hearsay. The fact of the matter is that that doesn't have to be considered by the court at all. Hearsay is not a concern when it comes to a preliminary injunction motion as far as the admissibility of evidence. Many cases discuss that, especially federal cases. And because the Nevada Rule of Civil Procedure 65 is modeled after and nearly identical to the federal Rule 65 for preliminary injunctions, this court can consider federal cases in looking at how to determine what to look at and what to consider in making a court's decision. Those federal cases largely hold that hearsay and other types of evidence which may not be admissible at trial are available for consideration by the court on a motion for preliminary injunction. And the case that says that the court can consider those federal cases is Las Vegas Novelty versus Fernandez. That's noted in our briefing. A couple of other cases that we talk about in our briefing that discuss what the court can consider and can't consider. GG versus Gloucester. I want to make a special point to make sure that I say this. That case was vacated and remanded by the U.S. Supreme Court, but on different grounds. It was vacated and remanded when the federal government changed the standards for schools in that particular area. There's a case in Nevada. Apologies, my handwriting is not very good. Department of Conservation, I believe it is. Department of Conservation and Natural Resources, Division of Water Resources versus Foley. That one's discussed in our briefing. And then Shadowwood HOA, which is also discussed in our briefing. There are additional cases in our briefing that discuss what the court can look at vis-a-vis evidence that may not be admissible at trial, and how the court can handle those things.
Go to your next sentence. Somebody's phone is still vibrating, please. Can you subtly turn it off? Unless somebody needs it for an emergency. I heard it a couple times. Sorry, I didn't want to interrupt you in mid-sentence, so
That's fine.
feel free, go ahead.
Thank you. Several other cases that we have in our briefing that discuss the sorts of evidence the court can look at. And we'll talk about how the court considers those here in just a little bit. The third point that I want to discuss is the delay point that Meta brings up in their briefing. I want to be clear here. The state is not, at least not solely responsible for delays in this case and for the length of time that it's taken between when our initial motion for temporary restraining order preliminary injunction was filed and today. We have entered into a few stipulations with defendant on setting dates and the time frame for this motion being heard. But by and large, the delay has been caused by the defendant's motions to dismiss and by the personal jurisdiction discovery that had to take place in this matter because the defendants challenged that. Now, obviously, the motions to dismiss have been denied by this court completely now. Those issues have gone up to the state Supreme Court and been denied twice now, though they are up. The defendant has requested en banc reconsideration now. That's being considered by the Supreme Court as well. But their writ application was denied twice already by the Nevada Supreme Court. And so those issues are behind us. And it turns out that their contentions there were not well founded, at least as far as the state is concerned. Meta complains that our motion, this motion, was filed 2 years after the state's investigation first began, speaking to the state's pre-litigation investigation under the consumer protection statutes. Yet they conveniently leave out the fact that the materials that were produced in the personal jurisdiction discovery, which we requested and we are requesting admission of here, were not produced during that pre-suit investigation and were only produced upon order of this court in the preliminary injunction matter. So I think the court should consider that as well when looking at Meta's claims of delay in this matter. The fourth thing I want to discuss is that the evidence that we are seeking to introduce is appropriate for supplementation after the March of 24 hearings. Most of the evidence that we are seeking to introduce was not in the custody or control of the state at the time of the evidentiary hearing. And a large portion of that was in fact in the custody and control of the defendant. That evidence was only made known to the state through the personal jurisdiction discovery process. We could not have known about that evidence prior to the hearing. And if we had known about that evidence prior to the hearing, we would have brought it to the hearing. Exhibits 1 through 16 of the list that we provided in our motion were all produced to the state between July 15 and July 24 of 2024, well after the March 20 and 2024 hearings. As regarding relevance to these docs, Meta claims that these documents actually support their position. We do not agree with that, for the record. We don't believe that contention is true. We disagree with that contention. However, even if that were the case, and those documents supported their position, then their argument that these documents aren't relevant must fail. The documents are either relevant or they're not relevant. Whether they support our position as the state or Meta's position as the defendant, if they support one of those positions, they're probative and should be considered relevant for this matter. Again, we disagree with their contention that they support their position. But if they believe they support their position and we believe they support our position, those documents should be considered probative and relative. Some of the evidence was produced after the hearing, and Meta talks about that a lot. Exhibit 17 through 21, Exhibit 23, and Exhibit 24. And I want to discuss those a little bit and just talk about why those documents should also be included for supplementation. Exhibit 17, State versus Smith, is a Nevada Supreme Court decision. And that case demonstrates and discusses in further detail the things that officers DeFonseca and, excuse me, I'm forgetting the name of the other officer who spoke, the state's witnesses talked about. Those are the difficulties that law enforcement goes through in securing evidence in matters pertaining to child sexual abuse material. The lengths that officers have to go through in order to get those things versus what a law enforcement officer would be able to do if end-to-end encryption were not a thing that Meta implemented for children's accounts, as we've discussed in the motion for preliminary injunction. And so that piece of evidence should be included because it wasn't available at the time of the hearing, because it's a Nevada Supreme Court case, and because it furthers the state's point. Meta is trying to confuse the issue with that case and trying to say that that case does not stand for what we're saying it stands for, and to say that it stands for you. Well, you see, the state has the ability to get these. We've never said that the state doesn't have the ability to complete an investigation into CSAM materials or into child sexual abuse. But the lengths and the efforts that law enforcement officers have to go through become much more severe when end-to-end encryption is in place on Messenger for children's accounts. And that's the point we're trying to make with that case. And that's certainly a relevant point and should be considered. Turning to the news articles that we have put in our list of supplementary evidence. Again, Rule 65 and the case law that we've already discussed contemplates that evidence that would be considered for a preliminary injunction need not be admissible at trial, because we're in equity, because this is a situation where justice is the prevailing aspect, and because of the other considerations that a court sitting in equity has to consider. And so exhibits 18, 19, 21, and 23 would be included in this discussion. Additionally, we point this out in our brief, we've included these news articles and Meta has said, well, those are hearsay. However, in their opposition to the state's PI motion, they also submitted third-party news articles for the court to consider as evidence. And so we think that by Meta using similar evidence, I'm sorry, I said we think. We believe the case would be that if Meta is using similar evidence to address their arguments, then the state should also be able to use similar evidence to address its arguments. Not only that, but that Meta's waived the argument by using that sort of evidence and then trying to say that we don't get to as the state. Exhibit 20 is the Report Act. Meta's indicated that they don't believe that is relevant. That is relevant because it demonstrates how dangerous Meta's disregard for NCMEC, the national,
You can just call it Nick.
NCMEC. Okay, thank you, Ryan.
We all know Nick Mick, you've
Yeah,
cited it enough times.
That's correct. How dangerous Meta's disregard for NCMEC reporting and their reporting requirements truly are. And then Exhibit 24 includes sections of the transcript of the 30B6 witness deposition, the 30B6 witness that Meta put forward in the personal jurisdiction discovery. And much like the other evidence Meta provided in discovery, that was obviously not available to the state beforehand. It's probative to the issues at hand and rebuts certain testimony and evidence from the defendant. Some of the evidence that we are presenting is in rebuttal to Meta witnesses' testimony in the hearing. Meta presented Miss Antigone Davis and Mr. Ime Archibong. I believe I'm pronouncing that right. Ime Archibong, thank you. And they presented declarations for these witnesses beforehand, and Meta's position seems to be that, well, they talked about this in their declarations, and so we shouldn't get rebuttal on those. But what was put in those declarations was not what was said in this courtroom. Those witnesses made statements that led to inferences and in fact, sometimes said things that were not included in those declarations. And so we have found evidence to rebut some of those things. And especially when we're talking about Miss Davis, I think we found some evidence that rebuts her statements quite well. As Miss Davis was sitting on the stand, she talked about NCMEC a lot. She talked about how she was on the board of NCMEC, and gave the general impression and the implication that NCMEC approved of or gave blessing to in some way their implementation of end-to-end encryption for the accounts. And so Exhibit 22 is evidence that we have found to rebut that. And Exhibit 22 is a statement from NCMEC talking specifically about the implementation of end-to-end encryption on Messenger. Now, Ms. Davis said she was on the board of NCMEC when she testified in March of 2024. This report, this document that we've propounded as Exhibit 22 was published in December of 23. But Ms. Davis didn't mention that document in her declaration. She didn't mention it in her testimony. We found it after the hearing, and absolutely we found it after the hearing. Absolutely, it was available before the hearing, but we didn't know we'd need that document because there was nothing in her declaration, nothing that the state knew beforehand, before the hearing where Ms. Davis testified, to suggest that she was going to imply those things and say those things. And so we think that is important rebuttal evidence for the state or for the court to consider, and we believe it's relevant and should be considered by the court. Similarly, with Exhibit 25, which is the declaration of Lawrence Howell with right of passage. Again, we heard things from the meta witnesses on the 20th and the 21st of March, 2024, that the state was not expecting to hear. And so we were able to find rebuttal witnesses, rebuttal evidence for that, and that declaration should be considered for that as well.
Can I pause you for a quick
You may.
second on this kind of section?
Mhm.
How is that any different than having a post-trial brief, right? I mean, and by the way, I'm not sure you're aware, you all actually did oppose their motion. It was filed around 2:40 something yesterday afternoon. I appreciate you got different people handling different things, but that's part of the reason why I asked my structure question
Mhm.
up front. I'm not ruling on the things that are in that, but you can appreciate the coincidental nature when one side saying, no, can't supplement, then file something that says, no, but we want to do something supplemental. The record's not closed for that.
Sure.
You're arguing, yes, the record's not closed, but then you're saying it's closed and they can't do it. So you can appreciate the court has to, in equity, address this concept of what, if anything, should be allowed versus a normal preliminary injunction hearing where it's at the end of the evidentiary hearing, unless there's a specific agreement or a court order otherwise.
Mhm.
It's done after the last person speaks, right? Or
Certainly.
any summary that the parties do. So
Mhm.
that's why I'm going back to ask you this question. If you want to do new, right, rebuttal, why wouldn't they get rebuttal? And
Certainly.
when does this end?
It ends when the court says it ends, I guess is the
I appreciate that, but
response.
to understand, I'm trying to get each
Certainly.
party's
Mhm.
viewpoint, because you're right, this is an equity, and you each are making requests, and want to make sure, things are fully flushed out, court has everything it needs to, and what's appropriate for it to rule on,
Mhm.
but at the same time, we're in May of 2025 on something that was emergency relief back in late 2023, early 2024.
Yes.
So that's question, right?
I think to help answer that question, we look at Meta's response to our motion to supplement the record,
Mhm.
where they say supplementation of the record through evidence is inappropriate completely. And so we obviously disagree with that position because we want this evidence considered by the court, and we think this evidence should be considered by the court.
But then could they bring up new rebuttal declarations to things that were either in your potential supplemental or witnesses from the state's end that testified that they think had inconsistencies? You understand,
Mhm.
that's normally the reason why we have preliminary injunctions. Now
Yes.
there's opportunities for motions for reconsideration after a court rules, right? For newly evidence, but I'm trying to kind of reconcile everything's here. And I appreciate it's a very important issue. I appreciate the breadth and depth of the issue. I'm in no way minimizing that in the least. I'm just trying to determine what is the right answer for this court to determine as to when, quote, evidence, so that the court can make its ruling on the emergency relief from over a year ago.
Sure. Well, Your Honor, I think the first thing that I'd say is that our motion to supplement the record was made fairly quickly after the hearing, relatively speaking. Meta's recent motion was made just recently. And so I think that is one thing that militates in the state's favor on why we should get our motion to supplement, but they should not get their post-hearing opposition. The other thing I note is that the court did keep open the record specifically when the court ordered personal jurisdiction discovery.
But and I'll pause you again there, because remember, that was one of the issues specifically raised, right? And of course, the court's gonna have to look at jurisdiction first. I mean, otherwise, I'm sure one side or the other would be, going down the street and saying, we've got to figure out the jurisdictional aspect. In fact, that was part of the argument, right? Let's figure out the jurisdictional aspect before the court makes a substantive ruling.
Right.
So I agreed with that. That's straight law and common sense as well. But
Yeah, it is.
okay, so, but there wasn't anything, I went through this whole record before today, again, surprise, right? No surprise, and I looked at each and every one of your stipulations, right? Drafted by very experienced lawyers. And they say what they say, but they don't anywhere say that things are going to be added to, right? There was very careful about the personal jurisdiction, the time frame, the scope, etc. And then it didn't say, and I'm not saying it should have, I take no position what things should or should not say, but I've had other cases where sometimes people say, and based on that, parties are going to allow X, right? That was not on this one. So how is the court supposed to reconcile that the parties' own agreements by stipulation and signed court order, I'll just phrase it easy, says what it says and does not include this concept? In no way saying something different from the EDCR, stuff like that, right? I'm just, here you all spend a lot of time coming up with these stipulations, which the courts signed off to give everyone the time they needed for all the different avenues, and they made sense, so of course the court signed them. But now are you kind of asking the court to say, well, you all stipulated to certain things and now the court should broaden what was stipulated to? Or are you saying, well, it wasn't necessarily contemplated, so that's why it's separate and apart from what the court's here today, or some third or fourth option? I'm not limiting to those two. That was a quandary I had because of the number of stipulations and the specificity of those stipulations post evidentiary hearing.
I think more the second of the two options
Okay.
presented, where there was not necessarily any contemplation at the time of some of those stipulations, especially early on. But once the hearing happened, once the testimony that was presented at the hearing by Meta's witnesses took place, then I think it comes a point where the court sitting in equity, who has to think of, who has to consider the justice and what the right thing to be done here is, with that less stringent and less set in stone sort of.
Wait from that, sorry, my court recorder is going to politely remind people that when you flip papers loudly near microphones, it goes into her ear. Sorry. We just want to make sure that you can nice clear record, everything you're saying can be heard.
I appreciate it.
No worries, no worries, no worries.
On purpose.
You can rustle one paper during theirs for 5 seconds.
Russell, okay.
At the risk of it going into my court recorder's ears. And if you want to take that risk, go ahead.
I prefer not to, thank you, Your Honor.
I'm doing fair is fair from my end, but there's a different concept. Go ahead.
That's
please.
all we're asking for is fair, Your Honor.
That's what I'm asking about.
We believe the court sitting in equity has to be able to consider as full a record as possible, that the rules and the case law say that that record is more inclusive than what Meta's position is that record should be. And we think that for the court to do that, the court needs to have these documents in the record. I think that's.
For this specific case, is there a specific reason? Or are you saying in every case where a court hears a preliminary injunction, these type of issues could come forward because the concept of equity isn't just this case number specific, right? It's each and every case in certain aspects, depending on the motion before a particular court. And you can appreciate that's a challenge, right?
Yes.
Go ahead. Thanks.
I think that is a challenge, but I think the case law leaves that possibility open. But I think it is a case by case type of basis. Not every case is going to have the sorts of facts and complexity that this one does. Some cases are going to have more complexity of facts, more complexity of the issues. Some cases are going to have less. So I think in this case, that is the situation that we're in. I don't know that it would apply in other cases, but it might. I do think that the law is pretty clear that when saying inequity, the court has broad latitude to consider what the court feels is appropriate in order to come to the right decision. The court asked about whether the state would believe that the defendant's motion should be granted. We don't. We
Wait a
think,
second, no, I did not ask if you,
I
I
may
said
have
I'm not ruling on anything that's coming before me on the 17th. I brought that only to everyone's attention because it is on the structural question, right? If you're arguing the record's open, but yet there seem to be certain
correct.
concepts. Other side might be arguing that the record's closed, but they might have a different concept and you might be defining record differently, right? And so where I'm going to is what, that's why I asked it purely as a structural question. What in your view should the court be considering? The same question I'm going to ask defendants, and I'm sure they wrote it down and know it's coming.
I apologize. I misstated what the court asked, and I apologize.
No worries.
That's my fault. We don't believe that that the record should remain open after our supplementary evidence is occurred. That's the state's position.
I gotta pause you because I'm not sure, and sorry, because I kind of asked the question and said a little bit. You think you only get your ability to supplement and they don't have an opportunity to respond to your supplementation? I thought I heard at the beginning you say something a little bit different.
I
So
may
I just want to have a clarity of
Yeah.
what your final position is.
I
without
apologize,
finding
Your
place.
Honor. I
No,
may have
as you go through oral argument, sometimes people's viewpoints change as they're thinking through things. That's what I'm asking.
I may have misspoken earlier. That's correct. We do believe the record should be closed after submission of these items. There are a couple of other things that I want to mention before I wrap this up, Your Honor. The defendant makes a big deal about the time between certain of the documents, and I'm speaking specifically to the documents that we received from Meta in personal jurisdiction discovery. They make a big deal about the time between when those documents were produced and the rollout of end-to-end encryption. The company, by their own admission, had been working on this project for a very long time. And so those documents maybe stem from the earlier portion of when they were working on it, not the rollout time period. So we don't think that that particular differentiation makes any difference. And we don't think that that particular argument is relevant to any argument about whether these documents should be considered or not. And I would point out that several of the documents that they are concerned about here, and again, this is exhibits 1 through 16, come from within just a couple of months or less of the rollout in December 2023. Again, the equity thing, courts routinely grant preliminary injunction motions on evidence that is less complete or would not be admissible. And just a couple of things from some cases here. One thing from a case, and this is from the Lemon versus Kurtzman decision from the United States Supreme Court. And this is in our brief, but I wanted to say it out loud. Inequity is nowhere else. Courts eschew rigid absolutes and look to the practical realities and necessities inescapably involved in reconciling competing interests. Again, that's Lemon v. Kurtzman, 411 U.S. 192 at page 201, and it's in the briefing. And if the court doesn't have any questions, I'll reserve the rest of my time for rebuttal.
Appreciate it. No worries. I do not have any more. Thank you so much.
Thank you.
Appreciate it. Okay, who's arguing this on the D side?
Me, Your Honor.
Okay.
Sneed on behalf of Madison.
Yes, chance to get up to the podium. And once again, you know, you can either use the podium, council tables, whatever y'all want.
I'll come on up here to make sure I have everything spread out.
Okay.
Good afternoon, Your Honor.
Good afternoon.
I wanted to start with the question that I believe you intended to raise with both parties.
The structure question, right?
Structure. What are we looking to do, given that both sides have briefs that raise the prospect of something supplemental?
Right, basically, the essence of it is, what are you contending is appropriate for the court to consider in making its actual ruling on the preliminary injunction motion?
Well, our position is that the materials that are appropriate for the court to make its decision is the record as it stood at the conclusion of the hearing. And we are not asking in any way, shape, or form for you to add to and look at additional evidentiary materials that were not presented at the time of the hearing or with the briefing that was submitted in relation to the PI leading up to the hearing.
Be a little bit more specific, so we're clear what you mean by the end of the hearing, right? Because remember, you're talking about as of March 21, 2024.
I am
You're
referring,
talking about something different. So you're talking about the original motion, opposition reply, testimony that came in during the hearing, and then everything's done as of March 21, 2024, and nothing else, or something different. That's why I just needed clarity what you mean.
let me clarify one thing first.
Okay,
There are two different things that I think we're talking about here and that we're talking about with the briefs. One is evidence. That's declarations, that's testimony, the evidence that actually is being put forward to support or against the PI. In our position, the evidence should be concluded at the end of the March 2024 PI hearing. That was the conclusion of the evidence. So we filed briefs, we included exhibits and declarations in those briefs, and ultimately we had a hearing that were multi-day that went through live testimony that forms the basis for the evidentiary world, the evidentiary record. That concluded at the time in March. Separately, there is legal argument. And what Meta is contending is that it is appropriate and in fact useful to have legal argument, a brief that uses the record that closed in March 2024 and looks back at that record, lines that record up with what the standard is for a preliminary injunction in Nevada, and explains why the record at the hearing and the materials that were submitted leading up to that hearing support or do not support a preliminary injunction. So all we're asking at this point in this hearing is for you to deny.
That's interesting. All we're asking at this point in this hearing.
Well, I want to
Should I be
differentiate.
checking to see if there's a new filing as I'm sitting here?
I want to differentiate between the motions that are pending.
Sorry, that was also a joke as to someone who, pardon? Sometimes it's not, you know what I mean? Okay, go ahead, please. I was not making light of it. I'm really just trying to. I just need the direct answer of what each side thinks this court should be considering, right? Original motion, opposition reply, and testimony and exhibits that came in the hearing, boom, that's it, or something else. And, okay, so.
For the purpose of evidence, yes, that is it. That is the evidence that you should consider when it comes to the PI. And all we're asking you.
Just have a third party article. Should I be considering those? Because they're quote, not evidence, are they? That's why I'm asking you the clarification question, because if I truly take the words that you're saying, right? Then that raises some more questions, because certain articles, certain references to certain things, right, came in not only in the hearing, but in the briefs beforehand. Are they evidence from an evidentiary standard? If this were hypothetically like a Rule 56 motion, right?
Right.
Or are you saying documents, exhibits? That's why, you know, you all are using different language. I'm trying to get clarity of what you mean, which is why I'm doing my follow-up questions. Okay.
What I was meaning to include in my set of materials was the exhibits that were filed in conjunction with the briefs that were filed leading up to the hearing.
Okay.
Any exhibits that were used at the hearing itself, the testimony that was at the hearing, and declarations that were submitted in advance of that hearing, which is part of the exhibits that were filed at the briefing. I think those represent the record in this case. I don't want to get caught up with the terminology. I'll just say in Meta's estimation, that represents the record, and that record closed when the 2-day hearing for the preliminary injunction motion concluded. All Meta is asking you separately, not for today, but in that other motion, is to be able to look back at that record that has been completed and concluded and argue that the state has not met its burden on the preliminary injunction based on that record that concluded in March 2024.
And on what basis and do they get to respond to that? A
We
new
are-
concept or not?
We certainly would, we
Because
do
it
not
takes it out of
oppose.
order. It's their motion for preliminary injunction, right? And then you're turning it into a different motion.
Well, we see it as no different as post-trial briefing. It's the same kind of idea. In the post-trial briefing, you're not bringing a new witness that's coming and reopening the record. No, you are arguing what happened at the trial and you're giving the court post-trial briefing on that topic. And the state, yes, would get an opportunity to respond to whatever brief that we file. And we do not oppose the state's ability to respond to that. All we're opposing at this hearing is the state expanding the world of the record to include new things that they identified after the conclusion of that hearing. So if I could have, it's almost as if all we're saying is we'd like a brief to be able to connect the dots that were already there. That's the record. What the state is saying is they'd like to add more dots after the record was closed. And we're saying, no, we should not add more to the record. Instead, all we're asking for is to say, based on the record that was developed, either the PI should not be granted. Does that clarify it for the court?
I'm hearing what you're saying. Go ahead, please.
At a high level, you know, our position is based on 2 points. First, the rules and the case law that's been cited, they don't support the state's proposal to add 27 new exhibits to the closed PI record. The EDCR doesn't state that they can do that. The cases the state cites don't establish that they should, and there's good reason for that. It's not fair to do so. The parties in this case and the court discussed and set out a clear procedure for how we were going to address the state's PI motion. They filed a motion, Meta responded to the motion, included declarations. The court ordered there to be a hearing. We had that evidentiary hearing, and at that time, both sides put forward their best evidence. That's the record. If they were surprised by anything that happened at the hearing at that time, they should have attempted to address it in cross-examination. And they could have raised any concerns they had about a new issue or something that was surprising at the hearing. They did not. Instead, the state now wants to come back and add materials to the PI record. And the proffered basis for it is to say, well, we found additional things in jurisdictional discovery, a process that was to address the question of personal jurisdiction, not directly to develop evidence for the purposes of the PI. They found additional things there. They found additional things on the internet afterwards that responds or rebuts to what Meta said at the hearing. Even if there was the ability to add evidence to a closed record, that couldn't be the standard for why you should get an opportunity to add to the record. Just the simple fact that, oh, we disagree with something that Meta said at the hearing does not mean that, oh, I get another opportunity, another bite at the apple. When does that stop? And how does that stop? In Meta's perspective, the conclusion of that hearing represents the closing of the record. Now, the repeated citation to there being equity, and there's an equity standpoint for this, must be able to respond to the evidence. Well, it actually establishes the procedural inequity that's here. What they're asking is to put in 27 new exhibits. And I think I heard counsel say that's the closing of the record. Well, in that situation, Meta doesn't get an opportunity to respond to the additional exhibits and materials that they have now poured into the record after the hearing has concluded. If you're talking about an equitable situation, that's fundamentally not fair. And so to allow the state to do so wouldn't align with the cases that they're saying. They've repeatedly mentioned that evidentiary rules are also relaxed on a PI because of the urgency. Well, the reason for the relaxation is because of that urgency. It has to happen now. It has to happen urgently. But the state, and as you've noted, the state has not moved urgently on this in the way that you would expect for a preliminary injunction.
Wait a second, please don't put words in my mouth. I did not say that the state didn't move as I would expect on a preliminary injunction or anything like that. I'm asking you each neutral questions so this court is able to ensure that I have a clear understanding of each of the parties' position and the support for their positions.
Let me respond to what was said about Meta's delaying tactics from counsel when he was arguing. There is no delaying tactics that happened from Meta's perspective in this case. When I went back through the record, I walked from one to the next stipulation, Doc ID 138, 198, 234, 290, step by step through the history of this case, where the parties talked and agreed that there would be a period of time by which they would file X, file Y, file Z. Nothing in there identified or explained or discussed or raised the prospect of reopening the evidentiary record at this late time. And I think that's a reflection on the fact that the EDCR doesn't say it, the cases don't establish that you should, or give the kind of standard that the state has given, which is that, it disagrees with something we heard at the hearing, or it surprised us at the hearing. It doesn't provide any of that in the law, and none of the stipulations that we've agreed to provide that. So what's the legal basis and procedural basis in equity for them being able to pour in 27 exhibits and Meta not to have an opportunity to respond? Now, besides the procedural problem that's here, I want to also raise the fact that at the PI hearing itself, the state attempted to put in additional materials on the eve of the hearing through their reply, and they submitted further declarations, if the court will recall, of Dr. Goldbeck, an expert witness, and additional declarations from their own witnesses that presented at the hearing. We raised an issue with that. We objected. The court heard argument about that issue, and the court decided to exclude Dr. Goldbeck's declaration and decided to exclude the declarations of those additional, the additional declarations from their witnesses. It was not allowed to be part of the record. Now, months later, almost a year later, we're back having an argument about whether the state is able to put more things in the record. In our estimation, Meta's estimation, the same analysis that the court gave and the same reasoning the court gave about the unfairness of bringing something in at the last minute applies with even more force to things that the state brings in after it's concluded, and particularly with Mr. Howell's declaration, which was put forward in this case. In Exhibit 25 in this case, the state's new declaration from Lawrence Howell. That declaration purports to provide more information and respond to what happened at the hearing, but it was the state's responsibility to prepare and present that information at that hearing. And it wouldn't be fair for them to get this additional declaration at this juncture. In addition, it contains certain opinions he puts forward, in my opinion. Any social media platform or messaging application that offers anonymity and or the inability of law enforcement to recover message content poses serious risk to children from child predators of all types. These third-party statements and potential opinions that they're putting forward is fundamentally unfair to jettison in after the record has been closed. And I have not heard a basis in the law for you to be able to do so, particularly if he's giving opinions of this nature when there's been no disclosure of him previously, there's no information about his background and CV except what's in the declaration. All of the problems that we identified before are present here as well. Now, the state also wants to put forward a document, exhibit number 22, about neckback. And the state concedes this was available 4 months before the hearing ever happened. They knew Antigone Davis was going to testify. They had a declaration from Antigone Davis about NECMEC and about Meta and about the issues that are in this case. And they opted not to bring that document and cross-examine her about it. Instead, afterwards, they say now this undermines what she says. And I think I heard that there's some statement that Meta put forward that NECMEC blessed Meta's use of end-to-end encryption, I would ask the state to identify where in the record that ever occurred, because I am not aware of anywhere that Ms. Davis stated that statement. And that's the basis for them saying that now a document they could have brought to the hearing is now needed to come in at this late date and supplement the record. Now, in addition, I want to address briefly the legal authorities that were put forward. They put forward Smith versus State as another document that they wanted to be able to be in the record. Again, that is a Nevada Supreme Court decision that is irrelevant to the actual decision that the court has to make about the preliminary injunction. It has nothing to do with civil litigation. It has nothing to do with preliminary injunction. It has to do with a constitutional right and whether or not there was appropriate steps that were taken regarding a search of a phone. The state wants to use it for a factual reason, wants to pull a Nevada Supreme Court opinion for a factual reason in this case without ever having raised and put forward that at the time. It's inappropriate to be able to use that for the purpose they're looking to use it. Now, it's not wrong if they have a case they want to cite, Nevada Supreme Court case they want to cite in briefing that they want that's relevant to the actual issues the court has to decide, but to pull facts from it and say this supports that law enforcement has a hard time doing something is inappropriate use of that case and is unnecessary. Similarly, the Report Act and an article announcing the law's passage. No one has made a claim in this case that the Report Act is involved or relevant to what's going on in this case. It's merely an addendum to say that this is an important issue. Even if the state could theoretically want to supplement, that can't be the standard or rationale to allow this late supplementation in the law. And then finally, I wanted to address the broad group of documents that were pulled from jurisdictional discovery, I think referred to as Exhibit 1 to 16. I think there are a few other ones that were there. And I want to address Meta's argument on that. Now, there was a lot that's made about, oh, admissibility doesn't matter, and you can consider inadmissible materials. Our point ultimately is that whether or not the documents themselves are admissible at trial, the relevance and usefulness and probativeness of these documents do not support allowing it to be supplemented in this case. Now, it said, it used a semantic argument to say whether it supports their view or whether it supports our view. Our point in our brief is not to say that these documents support Meta's position and so they should be considered. Our point is to say that the issues that were raised were already addressed in the evidence that is in the record right now. There was discussion with Antigone Davis about the concerns that were raised at the company before the rollout happened and about what was going on then and the work that needed to be done to be able to get ready for that rollout and the changes that need to happen. These largely 2018, 2019 early documents, it was stated that most of these were close to 2023 in Exhibit 1 to 16. That's inaccurate. Exhibit 1 is April 2019. Exhibit 2 is October 2018. Exhibit 3 is March 2020. These are documents that are plucked out from an early stage that and Ms. Davis addressed factually on the record as to the issues that were relevant. So in our estimation, it's not helpful to the court to add these materials that don't speak to the relevant issues about end-to-end encryption and the rollout of end-to-end encryption and about what Meta's views were at the time of the rollout inject it at this late date into the record. They have no bearing that helps. And the idea that just because the state says it might rebut or contradict, we disagree about that, but it shouldn't be a basis for supplementation to occur in any event. A couple more really quick points. Just as with the documents that were developed in jurisdictional discovery, we'd say the same thing about an attempt to use Mr. Winter's 30B6 testimony. It's not probative or helpful. It doesn't undermine. And if they had issues about location and age, as they've raised in their papers, those are things they could have addressed and in part did address in the testimony with Mr. Archibald. And so the idea that, oh, we think that now we've developed another inconsistency and want to raise that is not a basis for them to supplement the closed record that's here. And to the extent that they would expand such an evidentiary record, we would maintain that Meta should have an opportunity to provide a response on an evidentiary side to whatever is allowed. But in our estimation, the law doesn't support this type of evidentiary expansion and supplementation at this time. They've identified no place in the law where it says that it's appropriate for a PI in this situation to allow this after the record is closed at the end of the hearing. We know of none, and we'd maintain that the court should not allow it.
When you say the record was closed at the end of the hearing, how are you using that term, please? Meaning, are you saying the court said it's all completed, that the parties said it, or are you saying by operation of law, some fourth option? It's not clear when you're saying that it was closed as of the end of that day.
Well, I think I would go back to the procedure that the parties and the court entered into when the state filed its motion. We came and we were in front of you on more than one occasion after the filing of the TRO initially, and then subsequently the briefing that happened, and the court and the parties entered into stipulations that identified what was going to happen.
Stipulations, but go ahead, please.
The parties entered into stipulations and the court entered orders that explained what would happen in terms of developing a basis to be able to decide on the preliminary injunction motion that the state put forward. And it's our understanding that the court's order of an evidentiary hearing reflected a decision that was made to say that the court was going to take evidence on the preliminary injunction at that time. The court did take that evidence, and the conclusion of that hearing was the conclusion of that evidence. And so it is Meta's view that there's nothing in law that says that the ending is indeterminate and can be never, because the state's position is essentially that there is never any close of evidence for the purposes of a preliminary injunction record. Instead, if either party thinks that something they found disagrees with something that was said at the hearing, then that's a basis to reopen and restart the process. And we've maintained that that doesn't make any practical sense. And in all the equity that the state has really leaned on, it wouldn't make sense as a practical matter.
Okay. Appreciate it. Thank you so much.
Thank you.
You get last word. Go ahead, please.
Thank you, Your Honor. Phil Carlson for the state. To address the court's structural question. The hearing happened March 20 and 21 of 2024. Court ordered personal jurisdiction discovery. Personal jurisdiction discovery took place. There were some motions and some practice in front of the court regarding that. And there was a motion to compel, if I recall correctly, and a few different things there. Once that discovery period was completed, we filed our motion promptly on September 25th of 2024. And in the intervening 8 or so months, that Meta has had our motion to supplement. They haven't filed their own motion to supplement the record. They've filed 2 oppositions to our motion, but they haven't filed any request to supplement the record or to file any sort of competing evidence to the documents that we're asking the court to consider. So I think that is really the reason why the state believes that this information, these documents that we're asking the court to consider, should be the end of the evidence. Because Meta has had opportunity and Meta's had time to file additional evidence. I believe I heard Mr. Sneed say at the beginning of his argument that they don't want to file any additional evidence. And we think that the court should take that into consideration. The delay here, and I think what makes this preliminary injunction motion different than most others, is Meta's defense assertion of personal jurisdiction. Because that's, I mean, really the personal jurisdiction discovery and dealing with that issue is what has caused the delay between the hearing in March and now. If that hadn't been brought up, then we would have been done with this. Now, obviously, it's their right to bring that defense, absolutely, but that is the reason why we're here. And again, talking about equity, one of the things that I think the court should consider is the economy of this. Obviously, if this evidence is admitted into the record, the state isn't going to be asking to bring any other evidence. This is all the state's going to bring, and the issue can be done. And I think that will take a lot less time than if we have to bring this issue back up again because our evidence didn't get brought in. And then the last thing to discuss, the word I used was that Ms. Davis implied the blessing of Nick. I didn't say that she said it. There's not one point or one specific line in the transcript that can be pointed to say that she said that. But I think if you look at the totality of her testimony regarding NCMEC and some of the other organizations and entities, that a fair reading of her testimony would be that that was implied. We believe that based on that assertion, that implied assertion, that the judge, the court should have an opportunity to hear NCMEC's position on that, where they flat out say that this is an awful thing for children, where they flat out say that Meta's imposition of end-to-end encryption on this app is bad. And we think that should be considered by the court. That's all I have. If the court has any questions on the stipulations, any further questions on the time, intervening time here, Mr. Gayan would have a few things to say. If the court had questions for that, if not, otherwise, Your Honor, that's all I got.
Oh, I do have a question, but you know what I'm gonna do? I'm gonna say we've been going about an hour. We're gonna take a brief 10-minute break, because realistically, I'll tell you exactly what I'm gonna do, so you all can do it at the same time if you want to. You probably saw me pass a note to my court reporter, because trying to get the exact page of the transcript back from March 21, 2024. I looked at it in preparation for this, but there is at the end of the transcript, right? And the minutes reflect that the party said that they rested, and then the parties each agreed that they wanted to do a summation of the evidence. And you all might recall that, okay? So I want to double check the exact language that was used at the end of the hearing, because I would like to possibly ask maybe each side a question, depending. I just want to double check that language, because say to tree, I didn't print out everything, you know what I mean? So from the last year and a half. So it seems to me, so if you all independently want to look it up, you can too, because that's where I'm going to go to. Does anyone think I shouldn't? If anyone wants to object, let me know now. To see what you actually said back on March 21, 2024. Doesn't that make practical sense to everyone?
It does, Your Honor. Thank you.
Okay, so we're going to take a break. And now here's what I'm going to do. Marshall, we're going to take a different afternoon break. So I was going to allow the parties to stay in the court room, because I think I can look this up if you all need your laptops or whatever to look it up. Is that true? Or shall I ask you to go join the hallway? Just let me know if it's easier for you to stay in the courtroom.
I'm already on my laptop trying to look. So I would like to be able to sit here as possible.
Okay, I'll kick myself out of my courtroom. Go ahead. It's okay. Let's go back on the record. Back on the record. Okay, same party, same case, same attorneys. Here's the way I'm going to do it. I think it makes the most sense, rather than me ask really a series of questions back and forth. I give you each 5 minutes to say what you think. Or you can take less, or maybe you choose not to say, and they're not requiring anyone to speak, but I give each side 5 minutes to say what they're saying. Oops, I'm sorry, I didn't realize one attorney. You all didn't tell me you're waiting for one more.
You don't need to wait for me.
No worries, I would have if I looked around and asked. Okay,
You never have to wait for me.
The end of the next meeting.
okay, so.
From glass houses.
Exactly.
So if I give each side 5 minutes to say what their interpretation, because as you, depending on how much time you looked at the transcript, right? Including page 127 of the March 21st transcript, right? There's certain things that were said, but it's not a clear. Surprise, surprise, it wasn't a clear one sentencer like it is. Okay, so I think the better course is really to give you each 5 minutes or less to just explain what your viewpoint is of what was said on that day. Or I can ask you a series of questions, which I'm going to ask you about what was said on that day. So which way do y'all want it?
Your Honor, Michael Gayan for the state, if I could address this since I was the one
Sure.
handling it.
I'm just saying, but do you want to do it as the court asking questions, or do you get 5 minutes to say what you want to say?
I would prefer it, just 5 minutes to say what we have to say, but if
Then
the
let
court
me-
has specific language that the court has questions about, I'm happy to address that.
Well, it seems to me I'll listen to what each person says, right, and see what you're pointing out, and then see if I need to go back. Counsel for Meta, do you concur?
Meta's preference is to have the 5 minutes.
Okay, and if you need to change who's going to be saying it, we're fine on both sides. I think that's the fair thing to do, because this is something that the court's doing, okay? Or if you want to take it on, you can take it on. Okay, well, it seems to me that the movement gets to go last. That means Meta, you're going first. Unless you all disagree. If you want something different, let me know. Seems to me that's the way to do it, because you're getting an extra chance to speak and they still get last word. Go ahead, please, if you want to, and you're not required to.
Thank you, Your Honor. David Sneed for Meta. So looking at the transcripts, we actually would direct Your Honor back to the first day transcript, the March 20th transcript at page 201.
Well, that's document 76. Filed on 325, is that what we're looking at?
Filed on 325. Yes, Your Honor.
Okay, so transcript of proceedings for Wednesday, March 20th. Okay, go ahead, please.
That's correct. And the reason that we look back at that is because the function of the hearing went, the state proceeded first, and then Meta followed after that. So the conclusion of the state's case occurred on the first day, on page 201, lines 11 and 12. The state indicated that the state is ready to rest and let Meta call its next witness, subject to the offer of proof that Mr. Jones described before. So at the time, during my argument, I mentioned Dr. Goldbeck and the exclusion of Dr. Goldbeck. The state said that they wanted to offer a proof on Dr. Goldbeck, and the court said that they would that they would allow it. But at this time, the state rested its case, the conclusion of the state's witnesses after Mr. DeFonseca's examination concluded. So that's where I'd start, Your Honor. At the end, and then after that, Meta opened up its case with the testimony of Antigone Davis. Now going to the next transcript, which was filed on March 25th, 2024 as well. March 21, 2024, the transcript of the hearing. And if we go to page 121 of that transcript, it's the conclusion of Mr. Archibong's testimony. And if we look at lines 7 through 10, at the conclusion of Mr. Archibong's testimony, the court comes back and asks how to proceed if either party wants a summation, and the state responds, the state would like a brief summation, and would also appreciate about 3 minutes to make the offer of proof that Mr. Jones brought up yesterday. So at that time, Your Honor, that was the conclusion of the evidence that was taken in the preliminary injunction hearing, and both sides understood that to be the case based on the transcript because we were moving into summations. And after some discussion about how long the summations would be, the parties launched in, and that offer of proof that I mentioned, the parties launched into those summations. So our understanding is that the launching of the summations, the agreement, the closing argument for the plaintiff began on page 128 of that transcript. The evidence has concluded. And if we go finally to page 171 of the transcript, 171 lines 19 to 24.
And so we're in realistically.
Yes. And this is a statement that is the conclusion of the court's ruling. So the court's ruling begins on page 167, line 19, and then proceeds through multiple pages. And on 171, lines 19 to 24, the court states, Since I already have all of the evidence for the preliminary injunction, it's going to address the discrete personal jurisdiction issue right up front, and the court makes its ruling on the preliminary injunction based on the ruling that would happen on the personal jurisdiction issue. So I see that as an effective use of time. The court communicates to the parties that the evidence is in on the preliminary injunction, and you're going to address the personal jurisdiction issue right up front, because that's the logical way to proceed. So based on that, it was Meta's understanding, and based on what the state commented at the time, both in resting and at the conclusion looking for a summation, concluding that offer of proof, going into the summations. And it was our understanding, the court's understanding, based on the comments that were referenced here, that the record had concluded for the preliminary injunction.
Thank you. Like I said, state, you're more than welcome to have an opportunity. You don't have to take it if you don't wish to.
Thank you, Your Honor. Michael Gayan for the state. Just responding to Meta's arguments about the state resting on March 20th. That was certainly before the court's ruling on personal jurisdiction and that defense and ordering jurisdictional discovery. And it's clear from the court's comments that my colleague just mentioned on March 21st, page 171, that the court considered the jurisdictional discovery and ultimate decision to be part of the preliminary injunction proceedings. They were not. And now I know we've kind of, things have gotten flipped in their order because of the sequencing of things, but the motion to dismiss briefing was paused and then handled at the same time as this jurisdictional discovery for efficiency's sake. And those were some of the stipulations that we submitted, that it made no sense for the state to oppose the motion to dismiss on personal jurisdiction until that discovery was done. And so that was one of those stipulations. But the fact remains procedurally that the jurisdictional discovery all emanated from the evidentiary hearing, from the preliminary injunction motion and Meta's defense raised in response to that. So to say that the record closed when we finished, I think is just factually and procedurally wrong. That the majority of the evidence or documents that are subject or at issue in this motion to supplement came from that jurisdictional discovery. And so from the state's viewpoint, that is part of the injunction proceedings. Whether what was discussed prior to the court's ruling on ordering that jurisdictional discovery, it says what it says in black and white. I'm happy to answer questions. But at that point, the state didn't anticipate getting new evidence that the proceedings would continue. I personally never imagined being 14 months down the road and still talking about this. And unfortunately, that is just, and it's in the stipulations, it's just how this has unfolded, unfortunately, for the children in Nevada from our perspective. But here we are, and the court's equitable powers, I don't think there's any question that the court has the ability to consider this information. We're not asking to reopen the evidentiary hearing, have another one, do anything else, but these things all bear on, the exhibits in the motion to supplement bear on the court's ultimate determination, and the court has discretion to give whatever weight it wants to them. It might even be zero weight, but from the state's perspective, we believe the court's ruling at the end of day 2, ordering jurisdictional discovery, kept this proceeding open, and it would be, from the state's perspective, inefficient and unjust to have the court put on blinders and disregard documents that came out during that jurisdictional discovery that bear on end-to-end encryption.
But why? I mean, realistically, because a normal, I'm hearing what you're saying, okay, and I fully understand the significance of the issue. But if you go through, on the bench, what, about 14 years-ish, okay? Preliminary injunctions by agreement of parties continue off sometimes more than one day. But then once the parties have done their summation of what they think the evidentiary hearing has happened in those situations where evidentiary hearing has happened, the court makes a ruling. I believe I also, somewhere in the transcript you can find, I probably made a comment to Mr. Hester, I believe it was, something about the fact that I normally rule from the bench. Okay, because prior to new issues being brought up, you know what I mean? This court does oftentimes rule from the bench because of the situation with the preliminary injunction, because of the immediacy concept, right? The idea is you want to not only have a full opportunity for everything to be fleshed out and heard, but because of it's a preliminary injunction. Let me be clear, this was not a case. Someone feel free to correct me if I'm wrong, but this was not a case that anyone asked it to be a trial on the merits in the preliminary injunction proceeding. Is that correct from the state's perspective?
That is correct, Your
Is
Honor.
that correct from Meta's perspective?
That is
Yes,
correct.
sure.
Okay, because my statements I'm making are, don't apply when there's, you know, a preliminary injunction that turns into a ruling on the merits. Those are very different worlds.
Nobody
okay?
asked for a permanent injunction.
Yeah. Or even to turn it into, okay, so you have to look at the quote, temporal nature of a preliminary injunction. So why, and then if somebody disagrees with a preliminary injunction, right, ruling one way or another, sometimes there's either a new motion, a motion for reconsideration. Why in this case should the court be doing something different?
I'm happy to respond to
Yeah.
that, Your Honor. I think two main points. First, the court's ruling ordering jurisdictional discovery kept this motion. I don't know if pending is the right word, but it's not resolved. I don't think it's been fully submitted to the court yet. It's not under advisement. Your scorecard is 0, or however you all look at it from your side of the bench.
Mhm.
But and I'm not suggesting that it has been submitted for final decision. But the jurisdictional defense that Meta raised is going to have to be addressed in whatever order the court issues in terms of this motion for preliminary injunction. And the state presented all of that evidence first in its response to or opposition to the motion to dismiss, and the court has already made a ruling on that and applied tricargy and all of those things under 12b2 and looked at the evidence that was generated in the jurisdictional discovery. So the court has already looked at that, and it's going to have to be part of the injunction order, at least practically speaking, I think, to have a full order that addresses the defenses that Meta raised. They raised personal jurisdiction, section 230, and First Amendment. That was the first time we argued these issues, was it in the evidentiary hearing. So I know those have now been resolved by the court, at least in the motion to dismiss context. But I would imagine the order on the preliminary injunction motion would need to at least mention those defenses and that they'd been rejected in the court's prior motion to dismiss order, which looked at documents generated in the jurisdictional discovery. So if the court has looked at those documents, and to be efficient with the party's time and the court's time, and rule 1, why disregard other documents generated in that same process before actually considering and ruling on the preliminary injunction motion? Why only look at the personal jurisdiction documents and not the end-to-end encryption documents that were generated in that same court-ordered discovery period? So I think from an efficiency and a rule 1 standpoint, just, speedy, inexpensive, speedy is what it is at this point.
Speedy?
But just, and I think speedy and inexpensive still come into play because it would be grossly inefficient. We have taken a lot of the court's time already in this case, and on the injunction issues, it would be grossly inefficient to disregard those and then have the state bring a new motion for preliminary injunction that presents all of those for the first time, and we redo everything. That would be, in my view anyways, a waste of this court's valuable time. So this court has the discretion, with its sitting in equity for this type of an issue, to consider these things. And the court can assign whatever weight it wants. If it wants to accord less weight to some of that evidence because it came in after and wasn't presented to witnesses live, that's the court's discretion. But
With no chance of the defendant to have an opportunity to respond to quote evidence, which the purpose of an evidentiary hearing is for all parties to be able to fully participate, which I know I asked, remember, I asked you as I do in all my cases, right? I mean, not use the word almost all my cases, right? I'm sure someone can find one case I didn't, but is I asked the parties, right, to come up with your own structure, right? Your own timing structure and agreed upon, and if not, then the court provides one. But here, I mean, you heard me ask your colleague, final position is that your proposed evidence comes in and Medic doesn't get to do anything, and then I decide on that post-hearing?
That's
Are you aware
absolutely
that
right,
ever
Your Honor.
happened?
And that's absolutely right, and I'll explain why. We filed our motion to supplement in September of last year. It has been 8 months. Meta has not sought to put in any other evidence, and I believe I heard Mr. Sneed say Meta does not want to put any more evidence in. So they did respond to our evidence in their second opposition to the motion to
Let
supplement.
me clarify, because I understood Mr. Seed's statement a little bit different. I think he was saying that the court shouldn't consider that they feel that the evidence has concluded. He was distinguishing the motion that I'm not hearing today, the one that's set for June 17th, that in that motion, he was treating a argument brief distinct from the state's request to include additional evidence. And then I questioned him on what he really meant by evidence, because you both are submitting newspaper articles and other things which don't necessarily make an evidentiary standard under certain types of motions before the court. Let's just ask him if that's, don't you think the best way to do it? So we were.
My recollection was from an earlier part of his comments. I do recall the part where the court asked about articles and other such things. But my recollection, and I'd have to check the transcript after we're done today.
Can I ask him just
We
to make sure?
certainly asked whether Meta wants to submit more evidence.
Okay,
I want to be 100% clear. I did not, and I never meant to say that we would not submit additional evidence in response to the state's evidence. What I was saying was, it is our position that there is no need for the state's additional evidence at all, and the record is closed. And so it wouldn't make sense from Meta's perspective to have submitted evidence before now, because it is our position that the record is closed.
And that is their strategic, tactical decision to take that position, Your Honor. And the motion that shall not be named on June 17th, they are splitting hairs between briefs and evidence. And I think they did it in the opposition, the second opposition they filed on this motion as well. So that is a decision. So to say they have not had the opportunity, I think is false. They have had many opportunities to put in more evidence if they wanted to. They have chosen not to. They have chosen to take the position that the record is closed. Your Honor asked Mr. Sneed, where in the record does it say that? Is it from a court comment, a rule, operation of law? And I don't recall Mr. Sneed having an answer to that. And that's why we took the break and looked at the transcript. So Meta has taken the position the record is closed. I don't think the law or the transcript necessarily supports that. And that's why the state's position is take the motion to supplement those records, most of which were generated in jurisdictional discovery, and consider them. It would be most efficient. Meta has had 8 months to do whatever it wanted to do, put in competing evidence, and it has elected not to for tactical reasons. And there is no due process problem here. This is their strategic choice, and we do not need further briefing. They don't need a chance to respond. We don't need another evidentiary hearing. The court can resolve this motion to supplement today or under advisement or however the court elects to proceed. And then from the state's position, the preliminary injunction motion is ready for decision. Now, I know we have a hearing on June 17th, so maybe the court views that differently, and maybe we should hit the pause until then. But that is the state's position and the reasons for it.
okay, appreciate it. Has everyone had a full opportunity to be heard? State,
Yes, Your Honor.
Meta. It's a simple yes or no question.
There's one clarification I'd like to make based on what Mr. Gayan just
But
said.
they get last word. I mean, realistically, right? You're way
Yes.
past the time period you allocated. So I appreciate
I will leave it. I'll leave it. That is the conclusion.
on the issues with regards to the motion. Okay, but so I am going to rule today. And there's going to be the ruling. Plan to state Nevada's motion to supplement the record on order shortening time back from September, based on agreements and stipulations of the parties, came on for hearing and decision today. The court's decision is it needs to deny the motion, and here's the reasoning why. And it's a multitude of reasons. It's in no way with regards to the nature of the claims that are at issue. The court realizes there are significant issues from both sides. It's a very important issue, but here what the court has to look at is it proper to add additional potential evidence from a hearing that concluded on March 21st, 2024. And let me go back and explain a couple of different things. As everyone is cognizant, there were two types of issues before the court during that time period. One, did this court have personal jurisdiction raised by Meta? Two, and there was lots of other ones, so I'm going to give the two big ones, right? Two, from the state's position, should the court enter injunctive relief? Okay. Now, this court had to make a determination. Should it rule on the injunctive relief concept when there's still an outstanding issue for personal jurisdiction, or should it allow the personal jurisdiction issue to go forward? Fully hearing everybody and hearing their arguments, it made the most sense to this court, i.e. see the transcript on what I said, so I'm going to kind of paraphrase that again, that it made more sense to resolve the jurisdictional issue, because the jurisdictional issue, if you look at going back to 1Ls in law school, for many of us, it's been a while, okay? And since I'm from the 1980s, I can say that, okay? That realistically, 1L, what do you look at first? You look at procedure, right? Do you have subject matter jurisdiction? Do you have personal jurisdiction first before you look at other factors? In most general cases, I'm not going to go the nuanced exceptions, folks. This is not law school. So, but in general, that's the way you do it. So you have to look at, see if there is the personal jurisdiction issue. Then by agreement of the parties, and that's why I ordered some jurisdictional discovery. And then the parties agreed that timeline. That's why you're here today. The court, hopefully, I thought I was pretty clear, which is what page 171 was trying to say, is that I had everything, all the evidence I needed for the preliminary injunction. And then I needed to determine whether I could rule on the preliminary injunction, or whether or not, in my mind at the time, the personal jurisdiction issue needed to get resolved first before I could give my quote ruling from the bench. And then under Russ versus Clark County and Division of Family Services, that it could get memorialized into a written document, or whether I was going to write it up as a memorialized written document in the first place. Okay. See the transcripts. I then explained why I did what I did. I didn't say that means that we're going to take another day for an evidentiary hearing, because in fact, you all may recall certain people had certain schedules, all sorts of timings. I let and asked you all, as I do in the hearings, a variety of different ways to ensure that people had a full opportunity to see if witnesses were fully excused and everyone had been taken care of for purposes of the evidentiary hearing, which, if you recall, actually is an optional aspect that the court can decide is or is not necessary, i.e. see Johnny Ribeiro and his progeny when you have a motion for preliminary injunction. But I thought the evidentiary hearing was important to do. Therefore, we did it. It was not even necessary in some respects to rule on a preliminary injunction hearing, but we set it up because in this case, it was appropriate, the court found, and wanted to make sure everyone had a full opportunity. You had opportunities to do. Should we go back to the hundreds/thousands of pages that happened with regards to preliminary injunction and the testimony that came through, the declarations, etc.? So therefore, I'm not going to use the term record, because record, when I use the term, often means the entirety of the case from start to finish. So I'm using the term the preliminary injunction motion before this court, and whether or not after March 21st, the court should include anything else before making its determination. And I'm going to say no, but, and my no, but is, as I stated at that hearing, I needed to determine the personal jurisdiction issue and the outstanding motion to dismiss issues to see even if there was a case that was properly before Department 31 here in the 8th Judicial District. So that's my little caveat. Yes, but it wasn't to add anything additional for the preliminary injunction hearing. In my statements right now, I am being clear. This court is no way waiving anybody's rights to file any other motions. I'm not encouraging them. I'm not discouraging. I'm not taking any position. The law is what the law is. But so really going to the efficiency argument, it doesn't make an efficiency argument for this court to include on one side only somehow documents, exhibits, declarations, and responses to things that work as of March 21 concluded. I don't find that there really was a delay. That's not the issue. The issue is really what was the sum total of what this court needed, and this court had said by agreement of the parties in your own structured agreement as to how much time people had, what was going to be considered. That was all concluded on March 21st, with the caveat that this court had to confirm ascertain whatever words you would like to utilize, that this court had personal jurisdiction, okay? And didn't have another basis on a motion to dismiss that therefore took it away from this court to even have this case. And when I use the word take away, what I meant is the court did not have either jurisdiction, there was another legal basis that meant that this court should not be ruling on the ruling on the preliminary injunction. So that means need to deny it. When I look at the stipulations of the parties subsequent to the preliminary injunction hearing, it supports this court's ruling because there is nothing in any of those stipulations that any of the parties, despite very detailed, very organized, I can tell how much time and effort you all spent to go to those various stipulations, and there's many of them, right, over a significant time period, and none of them say, and the parties would like to X, right, add something to the preliminary injunction matter, or that the parties need to do X, nor is there anything that said a caveat that with regards that the personal jurisdiction discovery should also be included with regards to the preliminary injunction motion, okay? As very sophisticated attorneys representing, sophisticated clients, presumably, but only reason I'm saying that's because no one's a pro se here, so I don't have to do the discretion, you know what I mean? I would that somehow someone had no knowledge of the law. You all have the knowledge of the law. If somebody wanted that in, realistically, it could have been done in the last numerous months / over a year. And so I have to look at that. That's the reason why I say all of your stipulations support that. The transcript supports this court's position. The case law supports this court's position. Well, in equity, and I'm not saying that there isn't a case where sometimes it might be necessary, and I'm going to have one small little potential carve out here, is the court doesn't see in this case that there is one of those potential exceptions. For example, you all are familiar with certain bodies of law where there's a whole bunch of cases and the Nevada Supreme Court comes down with a case that totally changes the whole dynamic, right? That's not the case here. Whether or not the Smith case and the scope of a warrant and what was or was not included into a warrant has an impact is really something the court can evaluate when it's looking at the preliminary injunction aspect. So taking into account case law that has come about, that is brought to this court's attention, I would need to do. I don't see that as supplementing the record. I see that the court's doing its due diligence. If there's a case that's brought to its attention, to evaluate whether and if that case should or should not be considered, since both parties had an opportunity to address whether that case should or should not be considered. So that's what I'm saying, my small little carve out. So when I look at all of that, look at the transcript, look at your stipulations, look at the fact that you all had extensive briefing before we had the preliminary injunction evidentiary hearing. Remember, we first had the first hearing and then we went to the evidentiary hearing. So people had more than sufficient time, I think, from a due process standpoint to present as much as you wanted. And I think you all took full advantage of that. You had enough time, I believe, if you look at the length of the actual hearing, the evidentiary hearing, right? It was supposed to be partly one day. We got 2+ days, right? And remember, you went past 5:30, okay? So remember, I'm just saying, I'm only mentioning that point for the concept of that people had hours and hours of time to do testimony. There was objections. There was the offer of proof. All of those got taken care of. If the issue of wanting to add additional, what do you want to call it, exhibits, declarations, documents, however you like to call it, I don't care, use the word evidence, any of that could have been brought to the court's attention at that time, okay? It wasn't in the subsequent stipulations. So tried to give you much of an explanation as possible to address. I am not taking a position, just to be clear, on the merits of anything that was proposed to this court, on whether or not it is hearsay or not hearsay. I'm not taking into account whether it should or should not be included down the road. I'm not taking any position on the merits of any of the proposed documents, declarations, exhibits, etc. I'm only taking the position that it is not appropriate to supplement the motion for preliminary injunction that was brought before this court in early 2024, okay, and therefore that motion is denied. Okay, so Meta has just volunteered to do the very detailed order and circulate it to the state, right?
Yes, sir.
I thought that might have been the case. That's general the practice. I mean, if you all want to switch and you want the state to do it, then I'd ask the state, but generally if the court denies it, then,
We will do this.
okay. 14 days, CDCR 7.21 to the DC 31 inbox, or am I about to get a request that you need more than 14 days? Our local rule requires that proposed orders need to be submitted to the court within 14 days. You've heard me say EDCR 7.21 before.
We will submit within 14 days.
And circulate, you'll have enough time to get that done and circulate it around?
Yes, Your Honor, I think we could do that. And Michael Gayan can stay, yes.
Okay, so given the history of stipulations and extensions, I was just asking you up front. Okay, so now the next question. The next question is the phrases Mr. Gayan did, the motion that shall not be named, okay, that's on June 17th, okay? And the timing with, I guess, new characters being, anyway. That is a motion. I have an opposition. I don't even know if one side even had a chance to read the opposition. So I was planning on keeping it on the 17th of June, unless for some reason you can appreciate, guess what, I read them. But I appreciate time for reply hasn't yet happened, but I don't know if the parties for some reason want the court to address that today. If there was a joint agreement that you specifically wanted the court to address it today, I would. Otherwise, I'm keeping it on the 17th as it is currently scheduled.
Your Honor, Timothy Hester for Meta, we were planning to submit a reply, so with motion for leave to file, but we were planning to submit another paper, so we would like to keep it on the 17th.
Okay. So you all can appreciate, since that request is out there, you're not getting a ruling on the preliminary injunction, right? Because I view it as this juncture that because I have an outstanding motion taking no position on the merits of that motion, but similar to the idea that I wouldn't rule on something with regards to a preliminary injunction, if I'm determining if I have jurisdiction, you can appreciate you're not going to see a ruling before June 17th on your preliminary injunction motion, okay? And what I'm going to tell the parties, okay, and this is not in any way a ruling, is y'all might want to talk beforehand to kind of, since you know the landscape as of today, to see if parties have a viewpoint one way or another, you know what I mean, on what might be in everyone's interest or whatever. You're not required to do so, but now that it's out there. Okay, but otherwise I will see you on June 17th because I don't see that there's anything else currently for the court to rule on for today. If somebody does, please let me know. Counsel for the state, is there anything else you think that is outstanding for today?
Not as of right now, Your Honor, no. Michael Gayan for the state.
Like I said, I did check when we were gone for about the 10 minutes. I hadn't seen a filing, so. But we never know. And by the way, there was no new Supreme Court or Court of Appeals cases that came down today that I saw. Okay, that somehow would impact this case.
Always good on.
That there was one that came out, but it was a criminal case with Judge Lily Spells and had nothing to do with this case. I did read it real quickly to make sure. If somebody disagrees, I'll hear you on the 17th, I guess. So from the Meta's position, is there anything else?
No, Your Honor, thank you.
Okay, thank you.
Thank
I
you.
saw the nods, the negatory nods, but I just wanted to get, okay, appreciate it. Have a great one. Have a great rest of your day
Thank you,
and
Your Honor.
weekend.